Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss the legal victories and challenges to your fundamental freedoms and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, the President and General Counsel of Liberty Counsel, explains the latest legal issues all across this country in the courtrooms of America. Liberty Counsel is winning the battle for your constitutional freedoms.
The Supreme Court hands down a 5-4 decision on the Christian Legal Society. What are the implications for equal access? Hi, I'm Matt Staver, founder and chairman of Liberty Counsel and dean of Liberty University School of Law. Joining me is Matt Barber, director of cultural affairs for Liberty Counsel and associate dean for the law school. Matt, this was a 5-4 decision. I was at the oral argument. Liberty Counsel filed an amicus brief in this case. I watched how the argument went. I was not pleased with how it went. As I saw the justices ask the questions of the person representing Christian Legal Society, but I did not anticipate, I knew it was going to be 5-4, but I was hoping that at best we would have a clear win. At worst, it would be sent back for further information or further litigation, but not that it would ultimately be that this policy is upheld. What the court has done in this 5-4 decision, they've upheld a policy at a law school in San Francisco that is a so-called all-comers policy. The policy says that anyone who wants to come and participate in a student organization has the right to do so. That means not only attend, but also has the right to vote. If they have the right to vote, they have the right to also be officers. In this particular case, they wanted the Christian Legal Society group to sign an agreement that they would not discriminate on the basis of race, etc., and sexual orientation. That was contrary to Christian Legal Society's Christian belief, because they would not want people to be a part of the leadership that are engaging in sex outside of marriage, whether it's heterosexual or homosexual sex. So they were therefore banned from the campus. They filed a lawsuit, and now the Supreme Court, by a 5-4 decision, has sided with the law school.
Well, and Matt, of course, this 5-4 decision went straight down ideological lines on the Supreme Court. The far left of the Supreme Court, led by Ruth Bader Ginsburg, who wrote the opinion, came down and essentially said that this discriminatory policy that the University of California's Hastings College of Law has put forward, this all-comers policy, which was intentionally put in place to target the Christian Legal Society simply because the CLS has a policy that says that they will sign on. If you want to be part of the club of the Christian Legal Society, you will sign on to an honor code, essentially saying that you will honor and respect Christian sexual morality. That is, that sex between a man and a woman within the bonds of marriage is appropriate, and anything outside of that is sexually immoral. Well, because that would include activist homosexuals that are gaining so much political power in today's culture, the University of California Hastings College of Law put into place this discriminatory policy. Unfortunately, the United States Supreme Court, I think, has delivered a tremendous blow to religious liberty.
It's a huge blow. Now, they've challenged this policy facially, which means that they challenged it on the basis that you can't even have this kind of restriction. And I believe they should have won, that you could not require groups to have non-discriminatory policies on all these different areas. For example, this is how it will play out in real life. For the Christian Legal Society, they have to allow homosexuals or those that are engaging in extramarital sex or affairs to be part of their leadership. For the Republicans, they have to allow Democrats. For Democrats, Republicans. For the La Raza group, which they have a La Raza group on campus, they can no longer have ethnicity as part of a requirement to be a leader in the La Raza group. And of course, you have to have some kind of Latino ancestry to be part of the La Raza group. Now, CLS can still go back, and they can still challenge this on an as applied, which would mean that, all right, they've got this policy in place. Are they really applying it that way? Because in reality, the policy on its face is to operate exactly how I just described it.
Yeah.
Republicans have to admit Democrats, Democrats, Republicans. The women's group have to admit men for
Let's
leaders.
take it to the extreme.
And
How about
the
a Muslim group would have to allow Jewish and
Jews would have to allow Christians, and Christians have to allow
Muslims.
Muslims.
Yeah. It's absurd.
Yeah, that's how it actually works out. And what we do know is that they do have a La Raza group on campus. We also know that the La Raza group requires ethnicity as part of its requirement to be a leader in the group. So when they go back, they'll have to prove that the policy is not being equally applied. So they'll have to show fact, case by case, that here's these other groups, and you're not really applying it to these other groups. You're just applying it to CLS. Now, if they can do that, they can win. But the problem is that may help them win that case ultimately at this San Francisco law school. But what's going to happen now is that policy, the so-called all-comers policy, you're going to see that replicated on a lot of these public law schools around the country, public colleges around the country, and possibly it's going to go down and trickle down to the high school, so it'll affect Fellowship of Christian Athletes and others, where you have these student organizations on the high school, maybe even middle school level, all the way up to the college and graduate school level. Those policies are going to be applied across the board, and what we're going to see are battles trying to prove in each one of these situations on every one of these campuses that they're not equally applying the law, but they're unequally applying